Welcome to True Crime with Strategic Eyes.
Strategic back again. Welcome to another edition of We On That Ass News, a channel where we basically talk about news of the day and we follow these pedophiles around the world. So today we're talking about Stephan Sterns, and I want to update you guys on some new happenings that's going on in his case. Number one, it appears that Stephan Sterns is refusing to leave his cell. So therefore, the prosecution put out this motion that's basically asking the court to force Stephan Sterns to report to court on July 22nd, 2025. Now, I've been hearing on a few larger channels them talking about the possibility of Stephan Sterns taking a deal or plea bargain in this case. Now, I want to remind you guys, the audience, that True Crime with Strategic, yes, this show, approximately 2 weeks ago, talked about this before pretty much anybody else was talking about it. What we did is we looked at the deal that Bryan Kohberger got, and we made a show basically outlining how that's a model and a template for what's going to happen with Stephan Sterns. We did that actually before the decision on a motion for Stephan Sterns' cell phone seizure and cell phone dumping, etc., without the search warrant, etc. Before that ruling came out from the judge, where the judge basically said, hey, listen, we're going to keep that evidence in. We're not throwing that out. You lose, Stephan Sterns. If you thought you was going to win, oh, hell no! You was wrong. So now that that evidence is in, this is an open and shut case. There's not much defense that Stephan Sterns can put up to kind of say, hey, listen, I wasn't the one to do it. Like, basically, it's just mitigation. It's just, well, Stephan Sterns is trying to lessen his sentence or just roll the dice. Now, the problem with this case is that a conviction in this case gives the prosecution what they need to seek the death penalty in the next case, right? But it just doesn't make sense for Stephan Sterns to want to seek a trial. And I really harped on that in that video that we did, where we drew that comparison between Stephan Sterns and Kohberger and how he's most likely going to take a deal, right? And I also talked about how, you know, a lot of people have faith that, you know, Jay Williams is going to seek the death penalty. I mean, that's what he said he's going to do, but he's going to follow through with it. And I pointed it out to you guys that he has an inability and a non-willingness to seek any charges against Jen Soto. He even gave her derivative use immunity. And don't worry, we understand what that is. It's not absolute. It's not transactional immunity, but still, to give immunity to her, period, considering what we know about how she felt about some of the things that was happening in that household, as well as what she did to help cover it up, in my opinion, by not being completely honest with police officers in the aftermath when they're trying to find what they thought was a missing daughter, but turned it out to end up being a murdered daughter. It is what it is. He made that deal. He doesn't want to charge her. When you got a prosecutor like that, they're most likely going to be willing to take a deal. Understand, Stephan Sterns going to life in prison is just going to happen. The thing is, do they want to fight to give him capital punishment? Justice would still be served if Stephan Sterns spent the rest of his waking life in prison without the possibility of parole. As time goes by and tempers cool, the prospect of him serving life in prison just sometimes kind of makes more sense than to go through the whole rigmarole of a capital case. Whereas there's a possibility you may not even get the jury to side with you. We just covered another case on We On That Earth News with a defendant by the name of Walter. And Walter picked up a 15-year-old, engaged in a relationship with her, ended up killing her because he believed that he contracted something from her and gave it to his wife. Well, all of that was premeditated. So not only did we have essay of a minor, we also had premeditated unaliving. We had all that stuff. And the Tampa law enforcement, Tampa district attorneys, county attorneys, took this the distance. They wanted to get capital punishment. And guess what? A jury looked over it and said, oh, this guy had a tough life. He also argued he had a TBI. That's something that Stephan Sterns is going to be arguing. I guarantee you he's going to argue TBI if this goes the distance. And the jury said, nope, just give him life in prison. So even if Jay Williams pursues this as a capital case to the very end, there's no guarantee that that jury is going to say, yeah, give him capital punishment. We might go through that entire process just to end up with life in prison anyway, because if the if they give him a deal, he takes life in prison without the possibility of parole. That's what he gets. But if they go to distance for capital punishment and they lose, then he's going to end up getting life in prison without the possibility of parole anyway, right? Minus a couple $1 million from the taxpayers' coffers fighting for the capital sentence, right? And then also just add in that if they do get the death penalty, he's not going to be put to death for at least another 20 years because he'll have automatic appeals that will be paid for by the taxpayer until finally, if we're lucky, he loses those appeals and he gets the death penalty. But anyway, the next thing we want to talk about, guys, is another motion from Stephan Sterns, which I really don't understand because he already lost the motion for keeping cameras and YouTubers, etc., from covering the case and from having access to the courtroom. Well, I mean, I didn't read into this one, so maybe I'll learn something other than what I'm surmising based off of the heading of this motion, but it looks like he wants to get newspapers out as well. So let's go ahead and dive into this one and see what's going on. So defendant's motion to remove newspapers from courthouse during pendency of proceedings. Let's see. Come now, the defendant Stephan Sterns, by and through undersigned counsel, hereby moves this honorable court from an order directing the removal of newspapers from the courthouse lobby beyond the security checkpoint during the pendency of this proceedings as grounds therefore state. So I think what they're saying is get the newspapers out of the courthouse, not necessarily out of the courtroom, but out of the courthouse. I don't know, is his family or somebody else complaining that they're being, barraged by newspapers and harassed and interviewed, etc.? I don't know. This is kind of weird. I've never really heard of this before, but let's read on. The defendant, Stephan Sterns, is charged with 8 counts of battery, 5 counts of battery with ages 12 to 18, 7 counts of lewd lascivious molestation, and 40 counts of unlawful possession of materials depicting performance of forbidden ones. We're trying our best to respect the rules here. Okay, so let's keep going. 2, this case has garnered extensive media coverage throughout Osceola County and the surrounding areas, with developments in the case consistently making front page headlines in local newspapers, including but not limited to the Osceola News Gazette. Somebody give me a copy of that. The newspapers are currently made available in public areas of the courthouse beyond security checkpoints, including a lobby and waiting areas where potential and selected jurors frequently congregate. Actually, I understand now what they're saying. This is actually a decent motion. It really is actually a decent motion because what they're saying is, if these jurors, when we're doing jury selection, voir dire, or whatever, if they're privy to newspaper headlines right in front of them saying Stephan Sterns pedophile, yeah, that's kind of going to color their perception of Stephan Sterns. It's going to make them a little bit biased. But anyway, let's keep going. The newspapers are currently made available in public areas. We already read that. The 6th Amendment of the United States Constitution and Article 1, Section 16 of the Florida Constitution guarantee the defendant the right to a fair trial by impartial jury. In Shepard versus Maxwell, the United States Supreme Court recognized that courts have an affirmative duty to minimize the effects of prejudicial pretrial publicity. I don't know why they would have newspapers in the courthouse in the first place. It's a really odd place to have newspapers for this very reason. You never know when a case might have local notoriety, and now it's on the newspapers that's in the courthouse where the jurors have to meet. I would definitely approve this motion so far if I was the judge, if all they're asking is to remove those newspaper materials from these areas surrounding the courtroom inside of the courthouse. I think that that's reasonable, but we'll see what happens. Similarly, in Irwin versus Dowd, the United States Supreme Court held that exposure to presidential publicity can violate a defendant's right to a fair trial, where it creates a presumption of prejudice that cannot be overcome through voir dire. Okay. So they're going to be naming all the different administrative and court cases that basically prove their point. So we get to 12. It says, well, let's start with 11. 11 says, in the instant case, the extensive ongoing media coverage creates a substantial risk that potential jurors could be exposed to prejudicial information while physically present in the courthouse, the very location where the sanctity of fair trial rights should be most zealously protected. On March 4th, 2025, newspapers were prominently displayed in the courthouse with the headline, "Remembering Maddie." Wow. Referring to alleged victim in the case, such as most falsely charged headlines in the courthouse itself create an atmosphere that substantially prejudices the defendant's right to a fair trial. I think I agree with that. 13, of particular concern is the presence of these newspapers in the jury service room and at security checkpoints where potential jurors must pass through, ensuring their immediate exposure to potential prejudicial headlines before they even enter the courtroom. This is a good motion. I think this would be unfair for the defense. I do agree. The defense has observed newspapers containing prejudicial headlines in multiple locations throughout the courthouse, creating a pervasive atmosphere that could compromise the impartiality of potential jurors at every stage of their courthouse experience. The requested relief constitutes a reasonable time, place, and manner restriction as it is content neutral, applying to all newspaper regardless of their content, is narrowly tailored to serve the significant government interest of ensuring a fair trial, is limited to specific areas within the courthouse, and leaves open ample and alternative channels for the press to communicate information about the case. I really agree with this motion, ladies and gentlemen. I agree with the defense. I think that this is unnecessarily prejudicial and impartial to Stephan Sterns. We don't need Stephan Sterns to have grounds for appeal. We know that he is guilty as sin and he will have to pay for what he did. We don't want to give him layups, toss-ups, foul balls. We don't want to give him that stuff. All right. We don't want to give him home runs. All right. So this is one of those situations where he can now appeal if he doesn't get it, because he's going to say it's an impartial jury. Look at it. On this date and time, the Gazette posted my face all over the newspaper saying, guilty as sin, so says true crime with strategic eyes. And that was impartial and biased against me. And therefore, I didn't get a fair trial. And therefore, we need to throw this conviction out. Don't do that. I think this is a fair request. They're not saying remove the newspapers from the entirety of the courthouse. They're saying in the areas that the jury is going to be, remove those newspapers. They're also open to discussing other ways by which they could lessen the impartiality that this circumstance creates. It's a reasonable request. It's something that the court should work with the defense to remedy. So that's what we have today, ladies and gentlemen. I appreciate you guys immensely for joining me. Make sure you like and subscribe, join the channel, share this with your friends and family. This has been another edition of We On That Ass News, where we cover PD files from across the world. I'll see you guys on the next one. Strategic is out of here. Peace.